March 2026 is here, and if you are waiting on a green card, waiting on a visa, waiting on any kind of immigration benefit in the United States, then what I am about to tell you in the next few minutes could literally change the timeline of your entire life. I am not exaggerating. The March 2026 visa bulletin has dropped, and there are movements, there are retrogressions, there are some surprising jumps forward, and there are some brutal slowdowns that nobody was fully expecting. So if you have been checking your priority date every single month, refreshing the State Department website at midnight, losing sleep over whether your number is ever going to come current, stay right here, because I am going to break down every single category, every single country, every single chart, and tell you exactly what it means for you personally. And before we get into it, I want you to do one thing right now. Hit that subscribe button and turn on notifications, because immigration news moves fast, and the last thing you want is to miss a bulletin that changes everything for your case. Okay, let us get into it. Let us start from the very beginning, because a lot of people watching this video might be brand new to the visa bulletin, and I want to make sure everybody is on the same page before we go deep. The Visa Bulletin is a monthly publication put out by the United States Department of State. It tells us which priority dates are currently being processed for employment-based and family-based immigrant visa categories. Now, your priority date is basically the date your place in line was established. If you filed a labor certification, that date is when the labor certification was accepted. If you filed an I-140, your priority date is typically the date that petition was filed. And for family-based cases, it is usually the date your I-130 was filed. Now, the Visa Bulletin has two charts. Chart A is called the Final Action Dates chart. This is the one that tells you when USCIS or a consulate can actually approve your case and give you permanent residence. Chart B is called the Dates for Filing chart. This one, when USCIS allows it, tells you when you can submit your adjustment of status application, even if your priority date is not yet current on Chart A. And every single month, USCIS puts out a notice telling you whether you should use Chart A or Chart B. This is a critically important distinction, and I'm going to come back to this when we talk about whether USCIS has authorized the use of Chart B for March 2026. So the March 2026 bulletin is now published, and I want to go through every major category systematically so you know exactly where things stand. Let us start with the employment-based categories. Employment-based first preference, also known as EB1, covers priority workers. This includes people with extraordinary ability, outstanding professors and researchers, and multinational managers and executives. For most countries, EB1 has historically been current or very close to current, meaning there was no backlog at all. But as we have seen over the past couple of years, that has changed dramatically for India and China, which are the two countries most severely impacted by per-country limits under U.S. immigration law. For India EB1 in March 2026, the movement is something we need to discuss carefully. India EB1 has been stuck in a painful backlog for several years now, and the progression has been slow and frustrating for thousands of highly skilled workers who assumed that being in the first preference category would protect them from years-long waits. The reality is that the demand from India in the employment-based categories is so overwhelming relative to the annual numerical limits that even EB1, the highest employment preference, has a significant backlog for Indian nationals. For March 2026, we are seeing a modest forward movement, but nothing that is going to cause people to pop champagne. The date has moved forward by a few weeks, which is better than a retrogression, but for someone sitting on a priority date that is still years away from becoming current, it is a reminder of just how broken the per-country limit system truly is. For China EB1, the situation is somewhat similar. China-born applicants also face a meaningful backlog in EB1, though it is not quite as severe as India. March 2026 shows a slow but steady progression for China EB1, which is in line with the general trend we have seen over the past several months. If you are a China-born EB1 applicant with a priority date in the relevant window, you will want to check the exact dates carefully and speak to your immigration attorney about whether your case might be approvable soon. For all other countries, EB1 remains current in March 2026, meaning there is no backlog and you can proceed with your green card application without waiting on a priority date. This includes applicants born in places like Mexico, the Philippines, South Korea, Nigeria, Brazil, Canada, the UK, and everywhere else that is not subject to the specific per-country oversubscription we see with India and China. Now let us move to employment-based second preference, EB2. This category covers members of professions holding advanced degrees and people with exceptional ability in the sciences, arts, or business. It also includes national interest waivers, which allow applicants to bypass the labor certification process if they can demonstrate that their work is in the national interest of the United States. EB2 is enormously popular, and the backlog here, especially for India, is one of the most devastating immigration stories of the past 2 decades. For India EB2, the backlog is measured not in months or even years, but in decades. We are talking about priority dates that are currently in the early 2010s being processed. If you are an Indian national who filed an EB2 petition in 2015, 2018, 2020, or later, you are looking at a wait that could stretch well into the 2040s or beyond under the current system. It is a humanitarian issue masquerading as an administrative one, and it affects hundreds of thousands of incredibly talented people who have built their lives, families, and careers in the United States while waiting for a green card that never seems to come. For March 2026, India EB2 shows a very small forward movement of a couple of weeks, which is consistent with the pace we have seen. There is no dramatic jump here, and anyone expecting a major surge is unfortunately going to be disappointed. For China EB2, the wait is also significant, though not as extreme as India. China EB2 applicants with priority dates in the mid to late 2010s are in the zone of eligibility that is currently being processed. March 2026 shows moderate forward movement for China EB2, which is a bit more encouraging than what we see on the India side. For all other countries, EB2 is current in March 2026, which means if you were born outside of India and China, you can move forward with your green card application right now without any waiting period based on your priority date. This is one of the starkest illustrations of how unequal the immigration system is. Two people doing the same job, with the same qualifications, filing the same petition, face completely different timelines based solely on where they were born. Employment-based third preference, EB3, covers skilled workers, professionals, and other workers. For India EB3, the situation mirrors the broader challenges we see across the board. The priority dates being processed are still years behind, and March 2026 shows limited forward movement. The EB3 category for India has actually sometimes moved faster than EB2 in recent years due to a quirk in how visa numbers are allocated, and some applicants have done what is called a downgrade from EB2 to EB3 to take advantage of that faster movement. However, that strategy needs to be evaluated very carefully with an immigration attorney because it is not the right move for everyone. For China EB3, the movement in March 2026 is modest but positive. China EB3 applicants are watching the dates closely, and any forward movement is welcomed news after some periods of stagnation and retrogression in prior months. For the Philippines, EB3 is a category that many people track closely because the Philippines has historically had significant demand in the unskilled and other worker subcategories, particularly in healthcare and hospitality. March 2026 shows some movement for the Philippines in EB3, and this is important news for the large Filipino community in the United States that is navigating the immigration system. For all other countries not otherwise mentioned, EB3 skilled workers and professionals remain current or very close to current in March 2026. Now, I want to spend a little extra time talking about employment-based fourth preference EB4 and fifth preference EB5 because there are some important updates here. EB4 covers special immigrants, including religious workers, certain broadcasters, certain physicians, certain employees of international organizations, and others. The religious worker category has been subject to some uncertainty over the past few years due to lapsing legislative authority, but the category continues to be processed. If you are a religious worker or know someone who is, check the March 2026 Bulletin carefully and consult with an attorney about the current status of the program and any pending legislative extensions. EB5, the investor visa category, is one of the most complicated and fascinating parts of the immigration system. It requires a minimum investment of either $800,000 in a targeted employment area or over $1 million in a non-targeted employment area, along with the creation of at least 10 full-time jobs for U.S. workers. The EB5 program was significantly reformed by the EB5 Reform and Integrity Act of 2022, which changed the program substantially. For March 2026, the EB5 category for most countries is current or shows manageable wait times. However, for India and China, there are backlogs here as well. The China EB5 backlog is notable, as China has historically been one of the largest sources of EB5 investors. Anyone considering an EB5 investment should be working with both an immigration attorney and a securities attorney, as the legal and financial complexity of this visa category is significant. Now let us shift over to the family-based categories, which are critically important for the millions of U.S. citizens and lawful permanent residents who are sponsoring family members to come to the United States. The Family First Preference, F1, covers unmarried sons and daughters of U.S. citizens. This is a category that many people do not realize has a significant backlog because the immediate relative category for spouses, minor children, and parents of U.S. citizens is not numerically limited. But for adult unmarried children, there are annual limits, and the wait can be substantial. For March 2026, the Philippines F1 category remains deeply backlogged, with priority dates still in the late 2000s or early 2010s being processed. For Mexico, the F1 category is also heavily backlogged. For other countries, the F1 dates have moved forward, but there are still meaningful waits for many applicants. Family Second Preference has two subcategories. F2A covers spouses and minor children of lawful permanent residents, and F2B covers unmarried adult children of lawful permanent residents. F2A is arguably one of the most impactful categories for families because it affects people who are separated from their spouses and young children simply because the sponsor is an LPR rather than a U.S. citizen. For March 2026, F2A is current or very close to current for most countries, which is good news. The F2A category generally moves well because Congress has provided that it should be kept close to current, recognizing the humanitarian importance of keeping families together. F2B, however, has much longer waits, particularly for the Philippines and Mexico. Family Third Preference, F3, covers married sons and daughters of U.S. citizens. This is one of the most backlogged categories in the entire immigration system. For the Philippines and Mexico especially, the wait times in F3 are extraordinary. We are talking about decades. The priority dates currently being processed for these countries in F3 go back to the late 1990s and early 2000s. That is not a typo. People who filed petitions over 20 years ago are just now reaching the front of the line. For other countries, the waits are shorter but still significant, often ranging from 5 to 15 years depending on the country and the specific priority date. Family Fourth Preference, F4, covers brothers and sisters of adult U.S. citizens. This is the most backlogged family category of all. For the Philippines, F4 priority dates currently being processed date back to the 1990s. For India, the backlog is similarly extreme. For Mexico, the dates are also heavily retarded. For other countries, the wait times are still very long, often a decade or more. This is the category where the humanitarian cost of our broken immigration system is perhaps most visible. Brothers and sisters separated from their U.S. citizen siblings, waiting a literal generation for the chance to reunite in this country. Now, I want to take a step back and talk about some broader trends and analysis that I think are essential context for understanding the March 2026 Visa Bulletin and what it means for the immigration landscape going into the rest of 2026. First, let us talk about fiscal year dynamics. The U.S. government fiscal year runs from October 1 through September 30. The beginning of the fiscal year, particularly in the October through January period, is generally when the State Department can be more liberal in advancing dates because a fresh allocation of visa numbers has just been made available. As we get deeper into the fiscal year, the State Department starts to become more conservative to avoid running out of numbers before September 30th. March 2026 puts us squarely in the middle of the fiscal year, and this is a period where we often start to see the State Department pull back a little, slow down forward movement, and in some cases retrograde dates to manage the overall demand against the available supply of visa numbers. This is why some people who were hopeful going into early 2026 may be feeling a pinch right now. The mid-year period requires the State Department to make projections about how much demand remains in each category for the rest of the fiscal year, and if those projections suggest that demand is going to outpace supply, they have to slow down advancement or retrograde. Retrogressions, when dates move backward rather than forward, are one of the most painful things that can happen to someone in the immigration process because it can mean losing the ability to file, or in extreme cases, even losing filed applications that were submitted under the dates for filing chart. Second, I want to talk about the interplay between USCIS and the State Department. Every month, USCIS issues a policy announcement about whether it will accept adjustment of status applications based on Chart B, the dates for filing chart. This decision is critical because for many applicants, being able to file an I-485 adjustment of status application means being able to get work authorization and travel permission through advance parole while waiting for the green card to be approved. For the months in fiscal year 2026, we have seen USCIS authorize the use of dates for filing in many categories, but not all. You need to check the USCIS website specifically for March 2026 guidance to see which categories allow Chart B filings, and I strongly encourage you to do this the moment you finish watching this video. Third, there is the political context. Immigration policy in the United States in 2026 is deeply influenced by the political environment, and the March 2026 Visa Bulletin does not exist in a vacuum. Executive actions, court decisions, legislative developments, and agency-level policy changes can all have immediate and dramatic impacts on immigration processing times, visa availability, and the overall functioning of the immigration system. Without getting too deep into the political weeds, it is important for anyone navigating the immigration system to stay informed about the broader policy environment, because what is happening in Washington can directly affect your case timeline, your ability to travel, your work authorization, and more. Fourth, let us talk about visa demand and usage. The State Department tracks the demand for visas in each category from multiple sources: petitions pending at USCIS, applications at consular posts, and National Visa Center data. The interplay of all of this demand determines how the bulletin moves month to month. When demand is lower than expected, dates can advance faster. When demand spikes, often because of court decisions that free up a large number of petitions for processing, or because USCIS completes a lot of I-140 approvals that then generate new demand, dates can slow or retrograde. For March 2026, some of the movements and non-movements we are seeing are direct reflections of the current demand environment. Now, let us also talk about something that affects a huge number of people watching this video, but that often gets overlooked in visa bulletin analysis: derivative beneficiaries. When a principal applicant gets a green card, their spouse and unmarried minor children can typically get green cards as derivative beneficiaries, often using the same priority date. But here is something critically important. If a child is going to age out, meaning they are going to turn 21 before the priority date becomes current, they may lose their ability to be processed as a derivative beneficiary. The Child Status Protection Act, or CSPA, provides some protection against aging out, but it is complicated. It does not protect everyone, and there are specific calculations that need to be done to determine whether a child qualifies for CSPA protection. If you have a child who is approaching 21 and you are in a backlogged visa category, please speak to an immigration attorney immediately. The stakes could not be higher. Let us also talk about the Diversity Visa Lottery, also known as the DV Lottery or the Green Card Lottery. While the DV Lottery is technically separate from the visa bulletin categories we have been discussing, it is worth noting that DV numbers are also subject to annual limits and are tracked in the visa bulletin. For fiscal year 2026, DV applicants who were selected in the lottery and are going through the consular process need to pay close attention to the visa bulletin to understand when their case can move forward. The DV program has been the subject of significant political debate and legal challenges in recent years, and anyone currently in the DV pipeline should be working diligently to move their case forward because DV numbers expire at the end of the fiscal year on September 30 and cannot be carried over. Now let me address something that I get asked about constantly in the comments and through messages. What can people actually do to move their cases along? The honest answer is that there is very little an individual can do to accelerate the movement of the visa bulletin itself, because the bulletin reflects the State Department's management of annual numerical limits, and those limits are set by Congress. However, there are steps you can take to make sure your case is in the best possible position when your priority date does become current. First, make sure your I-140 is approved and that you have your approval notice. If you do not have an approved I-140, your case cannot move forward no matter what the dates do. Second, if you are in the United States and your priority date is current or close to current on the filing chart, talk to your attorney about whether you should file your I-485 Adjustment of Status application. Filing that application, even if approval is still years away, can give you access to EAD work authorization and advance parole travel documents. Third, make sure your National Visa Center file is complete if you are going through consular processing. Missing documents, unanswered NVC communications, or incomplete applications can cause delays that you do not need on top of the waiting you are already doing. Fourth, keep your address updated with USCIS. This sounds basic, but missed notices because of an outdated address have derailed more green card cases than you might imagine. Fifth, stay informed. Read the visa bulletin every single month. Follow immigration news. Subscribe to this channel. Talk to your attorney regularly. The immigration system is complex and constantly changing, and knowledge is your most powerful tool. I also want to address the broader emotional reality of what it means to be caught in this system, because I think that sometimes gets lost in the charts and the dates and the analysis. There are real human beings behind every one of these priority dates. People who came to this country, in many cases as young adults, built careers here, bought homes here, had children here who are U.S. citizens, and yet they are still waiting, still in limbo, still unable to change jobs freely or travel internationally without fear. The employment-based immigration system in particular has created a class of people who are trapped in what many advocates call immigration purgatory, permanent residents in all but legal status, contributing enormously to the country, but unable to fully participate in it. The call for legislative reform is loud and has been for years. Bills like the Fairness for High-Skilled Immigrants Act have passed the House of Representatives multiple times, but have never made it through the Senate. The elimination of per-country limits, which would treat all applicants equally regardless of their country of birth, has strong bipartisan support among technology companies, universities, hospitals, and the broader business community. But it has also faced opposition from some corners, and it has remained stuck in the legislative process. As of March 2026, there is no comprehensive immigration reform that has addressed these backlogs, and the Visa Bulletin continues to reflect the painful reality of a system that has not been meaningfully reformed in decades. For those of you watching this in India, I want to speak to you directly for a moment. The EB2 and EB3 backlogs for India-born applicants represent one of the most severe immigration injustices in the developed world. You are not alone. There are hundreds of thousands of people in your exact situation. There are advocacy organizations fighting for your rights. There are lawyers working on your behalf. There are members of Congress who understand the problem and are trying to fix it. The path forward is uncertain, but it is not hopeless. Stay informed, stay engaged, and keep fighting. For those of you in the family-based categories, particularly F3 and F4 for the Philippines and Mexico, I know the waits are almost incomprehensibly long. The pain of being separated from family members for decades because of a broken system is real and profound. The advocacy work being done by community organizations and immigration reform advocates to address these backlogs matters, and your stories matter. Now, one more thing I want to cover before we wrap up, and that is the interplay between the Visa Bulletin and other recent immigration policy developments. In the current political and policy environment of 2026, there have been significant changes to how immigration applications are processed, what enforcement priorities look like, and what options are available for people in various immigration situations. While the Visa Bulletin itself is a technical document that exists somewhat independently of these broader policy shifts, the processing environment around it is very much affected by them. If you are in a backlogged category and you are also dealing with questions about work authorization, travel, or status maintenance, it is more important than ever to have a knowledgeable immigration attorney in your corner. Do not rely solely on internet forums, social media groups, or even YouTube videos, including this one, for legal advice specific to your situation. Use resources like this to get informed, and then take that information to a professional who can advise you on your specific case. All right, we have covered an enormous amount of ground today. We have gone through the employment-based categories from EB1 all the way through EB5. We have covered the family-based categories from F1 through F4. We have talked about the fiscal year dynamics, the political context, the human cost of the backlog, and the practical steps you can take to protect your case and move it forward. I hope that this analysis has been genuinely useful to you, and I hope that it has given you not just information, but also a sense of what this process means and why it matters. And now, before I let you go, I want to leave you with something beyond the numbers. If you are going through this process, if you are waiting, if you are frustrated, if you are exhausted by a system that seems designed to make things as difficult as possible, I want you to know that your perseverance matters. The fact that you are here, informed, engaged, fighting for your future, that is not nothing. That is everything. The immigration journey is one of the hardest things a person can go through, and the people who make it through are not just lucky. They are resilient. They are informed. They keep showing up, keep filing, keep following the bulletin month after month after month. So keep doing that. Keep showing up. Keep checking the bulletin. Keep talking to your attorney. Keep building your life here while you wait for the law to catch up with the reality you are already living. And make sure you are subscribed to this channel, because next month, when the April 2026 Visa Bulletin drops, I will be right here breaking it all down for you again. I will see you then.